You're live.
Okay, Weblage ist jetzt live. Kann ich mal auf Wiedergabe? Mal schauen, ob wir... Ja, mit der Startfolie, super. Okay, jetzt live. Kann ich mal auf Wiedergabe? Mal schauen, ob wir... Ja, mit der Startfolie, super. Philipp, vielleicht müsste ich noch muten im Browserfenster das YouTube-Window, gell?
Wie, was nochmal? Halt.
Audio 2 noch.
Ja, vielleicht müsste ich noch muten im Browser das YouTube-Fenster. Das Video nicht gemutet.
Jetzt ist es gegangen.
Ja, jetzt ist gut.
Marc, vielleicht läuft bei dir das YouTube. Bei dir läuft, glaube ich, das YouTube ausschalten.
Das Video nicht gemutet.
Jetzt ist es gegangen.
Ja. Ja.
Hallo?
Philipp,
Vielleicht läuft bei dir das YouTube.
Browser, wo YouTube Livestream läuft, siehst du das Video und dort musst du es muten.
Ich hab's nicht. Ich dachte, das wäre bei dir. So.
Nein, das ist gut jetzt. Super. Da ist jetzt auch noch ein Teilnehmer. Manu und Simon. Dazu gestoßen. Dann haben wir noch 1 Minute und nachher starten wir dann.
Okay, so we can start. So, ladies and gentlemen, a very warm welcome to our Weblaw Brownback webinar series. My name is Philipp Hanke. I'm Director of Publishing at Weblaw. The idea of this series of webinars is to make good use of our lunch breaks, to get some insights into the work of academics, practitioners from different fields. And so, yeah, we have a couple of participants here on Zoom. We are also streaming live on YouTube. So hello to everybody here on Zoom and to everybody in the live stream on YouTube. Today, I have the pleasure to introduce Dr. Martin Hemme. He studied law at the universities of Geneva and Lucerne. And he then worked as a He then worked as a research assistant at the Institute of Public Law and the Center of Migration Law at the University of Bern. During his doctoral research, he spent some extended research periods at the Transnational Law Institute of King's College London and at the McGill Center for Human Rights and Legal Pluralism. He is talking to us live from Vienna because he is currently an Associate Crime Prevention and Criminal Justice Officer at the UNODC, that's the UN Office on Drugs and Crime, headquarters in Vienna, in the section for human trafficking and migrant smuggling. So welcome to you, Martin. It's nice to have you here.
Thank you.
He will share with us today the key findings from his doctoral dissertation, which was on the topic, the jurisdictional immunity of states in national civil proceedings for allegations of torture. So his thesis was a couple of weeks ago published here at Edition Weblaw. It is available here as a printed book, and as part of our open access strategy, it is also available for a free download as an ebook. Before we start, a quick technical note. You can, at least the people on Zoom, you can ask questions. So in your Zoom window, you will have a button called Q&A or F&A if you're using the German version. There you can type in a question, it's a chat window. And then Dr. Hemi will take those questions in the end of his talk. So I think with that being said, Martin, the floor is yours.
Sure, so let me just quickly share my screen. It says that I cannot share it.
I stop sharing mine. Try again.
Let me see. Yeah, now it's happening. Here you go. Yeah, so thank you so much, Philip, for this very kind introduction. And with this, I have to mention one disclaimer. As you mentioned, I currently work at the United Nations. So everything that I'm going to be talking about today is going to be my own opinion and is not reflective of the United Nations, of course. But I welcome everybody to this brown bag entitled The Jurisdictional Immunity of States in National Civil Proceedings for Allegation of Torture. And as Philip mentioned, this research is based on my dissertation that was recently published by Weblaw that is available free of charge on the internet where you could register for this webinar. Every time when I was asked to summarize or to explain what my dissertation was all about, I told the story of Sarah Kasemi. That's the picture that you see to the right. So Sarah is a Canadian Iranian photojournalist who worked for a Canadian journal. And in 2003, she was sent to Tehran at a time when student uprising were going on against the Iranian government. And since she knew the Iranian context and spoke Farsi, she was sent to Tehran to cover those students' demonstration. When she was there, during those demonstrations, approximately 4,000 people were temporarily arrested or temporarily disappeared, many of which were brought to Evin prison. That is the picture to the left. So when the next day, when Sarah appeared to Evin prison, she saw a lot of people waiting for their loved ones to see what had happened to them. So she started speaking to people, taking their pictures. When she was seen by a police guard and approached by this police guard that said that she has to give up her camera. Afraid that the pictures that she had taken would be later used to further harass those people, she intentionally opened her camera, exposing the film to the lights and destroying the pictures. For this, she was herself arrested. And unfortunately, not much is known after this. She was found dead 19 days later, lying in the streets of Tehran. Her dissertation, or the case becomes relevant in 2005 when medical records appeared that the doctor who performed the autopsy of Sarah had brought them to Canada, and that showed that she had deep scratches on her legs and her neck, that her nose and her head was smashed in, that fingernails were missing, and that she showed signs that she was repeatedly raped while in Iranian custody. The case is not, or the dissertation is not specifically about her, but about her son, Stephen. he tried to sue the Iranian government in Canada. So he tried to introduce a civil claim for damages against the Iranian authorities in Canada for the torture and subsequent death of his mother. In 2015, when I started this research, the Canadian Supreme Court said that the Iranian authorities enjoyed full jurisdictional immunity over the allegations brought forward and dismissed the claim. So this tension that is created between this so-called jurisdictional immunity of a foreign state on one hand, and individual rights to access to court and to remedy on the other hand, are at the central key of my dissertation. And I specifically ask if the forum state, I call them the forum state, so the court where proceedings are introduced, finds itself in a norm conflict, in a situation where it has to decide between jurisdictional immunity on one hand and individual rights on the other hand. So my book is subdivided in 4 parts. Part 1 talks about the foundations of this jurisdictional immunity of states, its object and purpose and scope. And especially it also talks about the sources in international law and in national law. But then already in part 2, I specifically look at already existing exceptions to this jurisdictional immunity in the context of asking the question, well, is torture an act that benefits from an existing exception from this jurisdictional immunity? So I'm asking the question, does the forum court still have the obligation to grant jurisdictional immunity when acts of torture are alleged? And I specifically look at 3 of those: waiver, exception based on Qualification Act, and territorial, tort exception. I'm going to look at 2 of those in a few minutes. But then in part 3, I'll specifically look at those potentially conflicting international obligations. And this part 3 represents half of my dissertation, where I go into much detail to figure out if there is an armed conflict, and in case there is an armed conflict, which should be given priority. Part 4 is conclusions. In the next 25 to 30 minutes, I'm going to pick out the main conclusions from my dissertation. I'm not going to be talking about all the chapters that I wrote about in the book, but refer to the ebook that is available for free and can be downloaded on the Weblaw website. So this jurisdictional immunity of states, what is it exactly? So it was described as the right of a state and its organs not to be held responsible for their acts by the judicial organ of another state. So we talk about an entitlement. Nowadays, we have recognized that there is an entitlement of a state. So there is an obligation from one state to another to grant jurisdictional immunity. But in a more general manner, the law on state immunity describes situation when a national court or tribunal can legally assess jurisdiction over a foreign entity. So there are certain situations where the jurisdiction can be assessed, and the whole framework on state immunity law describes situation and implements when jurisdiction might be assessed. This jurisdictional immunity must, however, be distinguished from other forms of immunity or other immunity-like concepts. First of all, I specifically looked at the immunity of the state as a legal entity. So I do not look at immunity of individuals, for example, of the head of state or of state officers. So I look specifically at the immunity of the state, strictly speaking, and exclude our personal immunities. And as I mentioned before, I looked specifically at civil proceedings, so not criminal proceedings. So when proceedings of damages are introduced against the state using the national court of another state. So this is excluding all criminal liability in this matter. And thirdly, I only look at immunity from jurisdiction. So the question if the court may, for the first time, assess jurisdiction to see if violations have taken place and recognizes, for example, right to reparation and remedy. I exclude the immunity from execution. So I exclude the question on what happens with the judgment later on, because these are different sets of immunity that are involved that I have to exclude because of time and space reason. Also, I only looked at immunities in international law and exclude all national forms of immunity. For example, parliamentary immunity or common law systems know the act of state doctrine that are very immunity-like, but they are not quite immunities in the international sense. So I exclude them as well. And I also exclude diplomatic consular immunity, immunities of international organizations or other forms of immunity. So really just the immunity of the state, strictly speaking. So why does it exist? So this jurisdictional immunity was created or evolved out of the Westphalian treaties. When Westphalian treaties were created, this new international legal order that was based, that was based on the equality, sovereignty, and independence of each state. So it was argued that the sovereignty and complete independence of a state must be protected through those immunity, because par in parem non habet imperium. So an equal cannot have jurisdiction over another equal. So assessing jurisdiction in this matter would disrupt this equality, would disrupt this sovereign idea, independence of each state, and would also violate the principle of non-interference. So this is the legal justification why those immunity exists. But in addition, there's also a few political justifications. It was said that immunities in general are necessary to make international cooperation and diplomacy possible. But it also protects, like in a more bilateral manner, it also protects the political, legal, and socioeconomic relations between two states, especially as we are going to see the state, the forum state, as I call him, and the state, the defending state, that proceedings are introduced against. In older texts, we also find this very interesting concept of the dignity of a state. It was argued in older texts that immunities must be granted because it would be against the dignity of a state to be subjected to the jurisdiction of another state. It has in recent times been a little bit of abandoned. It's still every once in a while, you can see it in legal texts being used, but mostly older texts that refer to this concept. In a more general manner, immunities find themselves in a very interesting crossway between two very big principles of law. We have the territorial sovereignty on one hand, and we have the equality of states on the other hand. So when we talk about when immunities are given, it's always a constant question of balancing of the absolute territorial sovereignty of a state on one hand, that must be weighed against the equality and sovereignty of a state on the other hand. It's very important to understand that this jurisdictional immunity is not absolute anymore. So there are situations already nowadays where I can walk down the street to go to the court and sue, let's say, the United States for damages if a specific set of preconditions are fulfilled. So already at the end of the 19th, 20th century, states have gradually adopted a more restrictive approach to understanding when immunities should be granted and when not. This was for the first time codified in 1972 in the European Conventions on State Immunity Law, that specifically sets out rules when jurisdiction has to be granted and when jurisdiction has not to be granted. And this was later confirmed by the ILC and the UN with a convention of 2004. Interestingly, we have a worldwide practice. So every state in the world except the People's Republic of China that still follows the absolute immunity practice, follows this restrictive practice. Basically, what does this mean? So basically, we have now acts of a state. So a state, when it performs certain acts, we must distinguish between acts that are immune and acts that are not immune. So this distinction, we call it, for example, acta de jure imperii, are acts that the state performs out of its sovereignty, out of its public authority it holds over other people, and are for this reason are immune in a foreign court. But there are also certain sets of acts called acta de jure gestionis, where the state acts in a more private manner, and these are not immune anymore. So we have we have to differentiate between those two acts. And why this is the case? It was said that we need to have certain sets of rules where procedural rights of an individual were considered more important than the sovereign equality of the defending state. So especially when the defending state acts in private law manner, it was said that the individual who is affected by these acts need to have available the possibility to ask for damages in its own court. A very important conclusion out of this was for me that a strict distinction between the procedural and material aspects of a proceeding are not possible anymore. So what does this mean? When it was sufficient during the absolute period of immunity that the defending state proves its statehood, it could just show up and say, hey, I'm a state. And that was the sufficient for the court to have to grant jurisdictional immunity. This is not the case anymore. So the court must necessarily look at what allegations are claimed, what material aspects of the proceedings are introduced, to figure out if an existing exception is not given. So we have a certain mix up between those procedural and material aspects of a case, something that we have to keep in mind when talking about the rest of, when talking about jurisdictional immunities and the implementation of jurisdictional immunities. So now we make a little bit of a jump. Now we look at those existing exceptions, and specifically we look at an exception based on the qualification of the act. So this is what I mentioned before, this distinction between acta de jure gestionis and acta de jure imperii, basically asking the question, well, if acts of tortures were committed, is it an acta de jure gestionis or is it an acta de jure imperii? And here, international law and law academics and courts have come up with a quite interesting way of differentiating the two. It's called the private person test. So they ask if the act in question could have potentially been performed by a private person. And if that is the case, then it's not, the state is not immune for those acts. So when it comes to torture, we have two groups of legal opinions. We have those that say, yes, torture is acta de jure gestionis, because crimes are by their nature something that can be committed by individuals. And so it has an individual character, and the private person test is fulfilled. And this makes sense because jus cogens violations, and torture is a jus cogens norm, are absolute limits on state action. So a state cannot claim that it has done those acts within its public authority it holds over other people. So because jus cogens violations are the absolute limit of state actions, violations of them must necessarily be acta de jure gestionis. On the other hand, we have opinions, and for example, the ICJ said that torture are acta de jure imperii, because violations of human rights can only be committed by state actors, or most of violations of human rights can only be committed by state actors. And this is especially the case when we look at the definition of torture according to its Article 1 of the United Nations Convention Against Torture, which says that torture needs to be performed under a public umbrella, so by a state actor or in the knowledge of a state actor. So here we have clearly an acta jure imperii element. Furthermore, and the ICJ is quite clear on this, it says it must be distinguished between the question if the act in question is performed legally, and if the act in question is an act for which the state enjoys immunity. Because assuming that that those two would influence each other, states would only be granted immunity for legal acts, and they don't need this because they didn't violate any norms. So this whole construct of immunities would basically collapse if we don't distinguish between the question of legality and the question of immunity. When I had to assess this element, so is it gestionis or is it imperii, I had quite a hard time because both sides have really good arguments. And I decided to first look at how this question has developed in another set, a very closely related set of immunities called functional immunity of state officials. Because there, torture is an act for which state officials may not receive immunity. And we have a set of justifications why this is the case. But interestingly, it's just that we have that a torture exception has been created, has developed within this jurisdictional immunity of state officials. So here illegality directly leads to the non-immunity. And this was quite interesting, something that I argue that immunities were created at a time where, for example, international criminal law did not exist. And this international criminal law that has now kind of like pushed this idea of prevention of impunity has also had a great impact on how we understand jurisdictional immunities to work. So a lot of things that we thought about how jurisdictional immunities work and do not work were actually becoming more difficult, or it has become more difficult to say those same things after the creation of international criminal law. So what I try to argue is that we should prevent a fragmentation of public international law in this matter. I do say that those are very distinct things, so that is the immunity ratione materia, how functional immunities sometimes go, and the acta de jure imperi are distinguished, are not the same thing, but I dedicated quite an intensive chapter on to see if what is the interrelation between those two kinds of immunities, jurisdictional immunities. But for a person who tries to sue, for example, the Iranian government, I concluded that solely based on this qualification question, it cannot bring a civil claim against a foreign state only on the basis of this qualification element, or qualification exception. But I criticize this private person test and argue that, and I'm not alone on this, by saying that this private person test has become quite unworkable in international law, and that lawyers and courts need to collaborate on this to come up with a better solution on this. Very quickly, a second exception that I looked at is this territorial tort exception. It is quite unique in international law, but has a very limited scope. So it only applies to physical damages, for example, bodily injuries. So here, torture could fall into this one, that were committed on the territory of the foreign state. So it's only that state where torture occurred that is allowed to lift the jurisdictional immunity of the defending state, and only if the foreign state agent was also present on the territory of the foreign state, and it only applies in peacetime and actions not performed by military. So it's a very limited exception that is quite unique in international law. It does not apply to transnational transport damaging acts, for example, nuclear disasters or environmental disasters that cause death or injury in another state. It does not apply to military actions or during wartime. The ICJ was also, it's not clear who is allowed to use this territorial tort exception, because the ICJ remained silent on the question if it was part of customary international law. Academics are actually quite forward to saying, yes, of course it is, but so far no international court has recognized its customary character yet. The interesting part, why am I talking about this, is that it applies to all state actions, so including imperii. And this is the first time that international law has foreseen a way that a state can be sued in a court of another state for its imperii acts. And this was quite, for me and for my legal reasoning for the rest of the book, this was quite fundamental by saying that even that the absolute protection of acta jure imperii has been given up in international law already now. So this was quite an important point, but nevertheless, almost all acts of torture with this very limited situation that I describe in this chapter 5 are crimes for which public international law grants states jurisdictional immunity. And this was the conclusion to my part 2. So torture is an act for which states enjoy jurisdictional immunity. And this leads me to my part 3 already. So part 3, well, does it cause any norm conflict? So this obligation of the forum state of the court to grant jurisdictional immunity for torture, does it cause any norm conflict? Does it cause any troubles? And one of the most discussed arguments in this is the so-called hierarchy argument, where this has been discussed many times in international law already. So this argument that, well, if torture and immunity enter into conflict, then of course torture should prevail, because as a jus cogens norm, it has a higher hierarchy position, so that it must be given precedence because of its higher position in international law. It's however not that easy to say this, because it's not clear whether a norm conflict actually takes place or not. The problem is the so-called procedure-substance dichotomy. It was argued that torture and immunity are not talking about the same thing. So torture is a purely substantive norm, substantive obligation not to torture, while immunities are purely procedural in nature and doesn't say anything about substantive obligations. And this is the predominant opinion, also supported by the ICJs in several judgments. But the question that I looked at is are use cogents really just purely substantive obligations? So are there maybe secondary procedural elements that might enter in conflict with immunities? And here I, for example, discovered that the prohibition of the use of torture evidence is certainly something that comes out of its use cogents norm that influences the way procedure needs to be implemented. But more interestingly, the obligation to assess jurisdiction over torturous acts, the so-called autedere ad judicare, is certainly a secondary procedural, like jurisdictional obligations that states have. In addition, also the universal jurisdiction, so the possibility to implement and sometimes even the obligation to assess jurisdiction for torture, are secondary jurisdictional obligations of states. The question is, however, do they also enjoy use cogents character or not? And in international law, on a global sense, it must say no. There's not sufficiently established use cogents character for these secondary procedural elements, but the Inter-American Court is quite active here. So the Inter-American Court has been pushing quite far to include those procedural elements, procedural obligations, also to be involved in use cogents. So we might have something about regional use cogents. I do not want to open this Pandora box to talk about regional use cogents, but for now, it is said that that no non-conflict arises out of this. Nevertheless, I want to reaffirm something that I have said earlier, that it has become increasingly unuseful to do this differentiation between substantive and procedural obligations because of how jurisdictional immunities must be implemented. So the strict distinction between procedure and substance is not useful anymore because those material and procedural aspects of a proceedings have become mixed up already now. And especially when looking on the consequence of this procedure substance distinction. And we're talking about de facto impunity for international crimes here. Victims have no other way to receive access to justice or reparation. A certain set of authors have proposed that it is not enough to just look at torture and state immunity in a vacuum, so that especially state immunity law must be seen through a more contextualized international legal order. For example, in common law, this is called the statutory and interpretation approach. So they argue that the legislator, when adopting, for example, legislation implementing foreign state immunity law, has always acted with international law in mind, so that it could not have intended something that is contradictory to the rest of international law. So it's said that we need to do a more contextualized interpretation of what state immunity law is within the wider context of public international law to maintain a coherent legal order that is free of contradictions. And here I quite have kind of my playground. So I looked at 3 specific developments in international law that would rather contradict or rather big tensions are created to this continued concept of jurisdictional immunity for use cogents violations. These are, first of all, the growing concept framework. It's becoming bigger and bigger to the fight against impunity that, as for example, also has developed so far to allow for universal jurisdiction. But secondly, also this humanization movement that has taken place, especially with regards to sovereignty and equality, that must be taken into consideration as well when talking about jurisdictional immunities. And thirdly, we have to talk about the enhanced position of the individual in international law that also impacts on how we see jurisdictional immunities as well. So the conclusion that I do in this chapter, and this was one of the main chapters of my book, is that the systematic grant of jurisdictional immunities for torture is fundamentally contradictory. So there are great tensions created by this immunity for use cogents violation that is contradictory to the to fundamental principles of international law. I also tried to show that a torture exception to jurisdictional immunity would not be something new. We, for example, have already seen that law already allows for jure imperii, exceptions right now, but also that other forms of implementations, for example, universal jurisdiction, has already been created now. So I try to argue that it's not a question of if we can do it, but just like in what kind of situation we should be able to assess jurisdiction or not. A second conclusion, and this is also very fundamental for my research, is that state immunity law uses a concept of sovereignty and equality that is outdated. Does not take into account any recent development, so that they basically still use sovereignty and equality as it was understood in 1648 in the Westphalian peace treaties, and that I try to urge law practitioners to take into account that those concepts have significantly changed since then. And this becomes very important later on in a chapter regarding the access to court rights. Furthermore, this unilateral adaptation, so this statutory interpretation approach that I describe in this chapter, is something that that the court would have this tool in his quiver, but that it might be democratically questionable to do this, to deviate from existing law through this mechanism. So I do say that a unilateral adaptation of court is legal, but for many reasons democratically questionable. Another way that I looked at, and this is also quite a big chapter in my book, is the question if countermeasures are a possibility. And I was surprised to see that not a lot of law professionals had been looking into this question. So the question, does the court, can the court take countermeasures, judicial countermeasures against the jurisdictional immunity of a foreign state in order to give a victim of torture access to its court? And interestingly, international law does allow this. So judicial countermeasures against the jurisdictional immunity of a state are compatible with international law, as long as it is a jus cogens violation. This is especially regarding the proportionality of the tool, and only when certain procedural steps have been respected. So this is a legal way. So this could be a legal way for courts to let victims of torture, let's say, use their courts for bringing civil claims against a foreign state. This has advantages and disadvantages. First of all, the advantages: it is a de lege lata tool. So this already exists today. This possibility already exists in the legal order nowadays. So it can be done now. And it is in line with state practice and the ICJ judgment. So what do I mean by this? The countermeasures are, by definition, acts that would otherwise be considered a violation of law, when following this precondition set out by law, is not something that is that the state has responsibility for. So it is this act would otherwise be a violation of law. And by saying this, when you take countermeasures against this jurisdictional immunity for jus cogens violation, you by definition also endorse the continued concept of this jurisdictional immunity for jus cogens violation. As I said, it gives direct access to justice for victim of torture, and it is quite a flexible mechanism. So courts have all the leeway, so they can decide upon how and when and who can refer to this, or how it is implemented, how these countermeasures are implemented. The disadvantages are quite clear. There is no entitlement for the victim that the court takes this countermeasure. It is a purely political decision. I do, however, argue that the court has an obligation to at least inform the executive branch and to coordinate with them. And of course, this causes a lot of tension, not only between the judicial and the executive branch, but also to the defending state here. So we have a certain conflict potential here. Very quickly, the next chapter was focused on the right to access to court. I specifically looked at the European Convention on Human Rights here because of space reason, but argue that similar findings could be found when, for example, using the second protocol, the UN covenant, the second UN covenant. So I specifically asked the question, well, if the court, the civil court in question, grants this jurisdictional immunity to the foreign court, does it violate this Article 6.1 of the European Convention of Human Rights? And the first question that needed to be clarified is, does it even apply? Does Article 6 even apply? And here it is quite overwhelmingly decided yes. The European Court of Human Rights consistently say and also come to the conclusion that Article 6 is applicable to civil proceedings introduced by a victim of torture against a foreign state. And assuming this, so assuming that the convention is applicable, it also means that jurisdictional immunities or the grant of jurisdictional immunities are a restriction of this right. And that means that the procedure for a restriction of those rights must be followed. And here I look at legitimate interest, proportionality, and essence of the right. Very quickly, I conclude that there are certain legitimate interests, so that the court has a legitimate interest to grant this jurisdictional immunity, for example, the respect of international law, and also the protection of sovereignty and equality of states, in the parentheses that they really understand these concepts, so this sovereignty and equality of state in a modern understanding, so as how the international legal order understands them now and not how they understood them in 1648. I do say that, for example, practical obstacles for the proceeding and implementation of the judgment are not legitimate interests in this specific case. So in a case where a victim of torture introduces civil proceeding, practical obstacles are not legitimate interests for the restriction of access rights. When it comes to proportionality, the European Court of Human Rights usually gives a lot of margin of appreciation to the states. So it is probably not the best forum to appreciate in detail proportionality element. Nevertheless, I have discovered certain contradictions within the jurisprudence of the European Court of Human Rights, especially as it relates to other forms of immunities, especially the immunity of international organizations. And again, I stress again that every proportionality assessment must take into account this conceptual change of sovereignty and equality, and also all recent developments of law that I had mentioned in the chapter before. I conclude that proportionality assessment must be done on a case-by-case basis. So it's not possible to conclude that, for example, victims of torture always when they try to sue a foreign government and the foreign government receives jurisdictional immunity, it's not always a violation of Article 6. So we must do a case-by-case analysis. But that a lot of the cases that have been discussed by the European Court of Human Rights were, in my opinion, a violation of Article 6 already at the proportionality assessment. But latest, when we look at the essence of the right question, and I was surprised to see that the European Court of Human Rights rarely really assessed this element. It usually mixed it up with the proportionality assessment. If we all the way make it to the essence requirement, it's increasingly become difficult to not find a violation of Article 6 in this perspective. So first of all, there is an alternative forum test applicable. So saying that if the person or if the victim of torture has no other way than just using a foreign court for introduction of civil proceedings, then there is a violation of the essence. So there must be an alternative forum available. And we look, for example, I look, for example, at the National Court of the Defending State. So, well, can we just use that one then? And here, generally, we have to say yes, but there is a certain refoulement effect applicable. So I recognize a certain refoulement obligation to just for the national court. So, for example, the Canadian court in the example of Sarah Kasemi would have only been able to refer to the Iranian courts for the introduction of civil claims if they protect at least a similar protection of Article 6 or Article 6 equivalent rights to the victim of torture. And this is in most cases, in most instances, was this not the case? What I do conclude is that diplomatic protection are not an alternative, are not sufficient alternative for the protection of essence of the right. So what I'm saying is, what I conclude in this chapter is that in many instances, violations of Article 6 take place when a court just generally grants jurisdictional immunity. And that I urged especially the European Court of Human Rights to be more clear on certain elements and to recognize specifically when proportionality assessment must be done, what elements need to be taken into consideration, and especially look at this essence requirement in more detail, which so far has not been happening. Very quickly, and I'm going to look now at my time, so I'm not going to be losing a lot of time. The last chapter I looked at was the right to reparation and remedy, asking the question if this right, especially the one contained in Article 14.1, is violated when jurisdictional immunities are granted. I do a very detailed assessment of interpretation mechanism of this 14.1 and conclude that those methods applied do not show one solution, but that according to the ut magis valeat quam pereat principle that says that a treaty is better to apply than not to apply, I conclude that Article 14.1 enters in norm conflict with jurisdictional immunities as well, and because of its lex specialis character, that it actually deserves as well, like that it also takes precedence over the jurisdictional immunity of a foreign state. Very quickly as well now too, this would of course create a civil universality principle, and I tried to talk about this a little bit because a lot of authors are a little bit scared of this universality, civil universality. So first of all, universal jurisdiction in civil matters is compliant with public international law. This was, for example, said by the European Commission: when properly exercised, universal jurisdiction affirms fundamental principles of international law. There is already now a certain state practice. For example, the United States, Canada, and the Netherlands have decided cases claiming universal civil jurisdiction in torture as well. And also that any country which has adopted the so-called adhäsionsverfahren, so where, for example, the victim may take part in a criminal proceeding as a civil personality, so action en partie civile. This is already also a kind of practice. So in the implementation of universal criminal jurisdiction, this would also lead to the implementation of universal civil jurisdiction. What I also conclude is that a differentiation between universality in criminal and civil matters do not go as far as to justify a difference in application. This was, for example, said that it sometimes must be even included, so that civil universality must be included in the universal criminal jurisdiction. And this floodgate argument that a lot of authors bring forward can be mitigated. So I propose a specific set of legislation, a specific piece of legislation that would allow to give a reasonable limitation on this floodgate fear. This is the 2010 UK Torture Damages Act in combination with Article 2 of the 2015 Institut de Droit International Tallinn resolution. So very quickly, the conclusions. This relationship between immunity and access to justice, reparation rights of victims of torture is complex, to say the least. Civil courts, according to my opinion, to my legal opinions, find themselves in a position of conflicting international obligations. The thesis describes several ways on how this non-conflict can and must be resolved, for example, through a contextualized interpretation of public international law, through judicial countermeasures, through a legally conform interpretation of Article 6 of the European Convention of Human Rights, or through the recognition of the extraterritorial effect of Article 14.1 of UN CAT. I also propose a specific law proposal for a reasonable implementation of universal civil jurisdiction. And very, very fast, it is interesting to see this subject remains quite interesting, especially the United States have been quite active in recognizing reparations to victims of torture. For example, in 2019, in the case of Otto Warmbier versus North Korea, they have found that the victims, the surviving parents, were that North Korea needs to pay over 200 million in reparations in that case. So this is an interesting or a very recent topic that needs to be discussed. So with that, I'm concluding. and give back to Philip, if he can hear me.
Yep, I'm back.
Yes, great.
So awesome video. Okay, thank you very much, Martin, for this overview.
No problem.
My quick question is to the audience, if you have any questions. I do not see any questions in the chat. Maybe to give one more second to the audience, I will include some advertisement in the meanwhile. To change screens here. Yeah. So of course, Dr. Hemi worked very much in detail. He produced a 450-page dissertation. So you can order it online or just download it. You can find it on weblaw.ch/Hemi. I'll do a last check about if there are any questions, but no, I do not see any.
That's fine. So I wish everybody had a good lunch though.
Yeah, even though maybe it's not a topic where you really enjoy your lunch. Torture. But so thank you very much, Martin. Thank you very much to the audience here in Zoom and on YouTube. And I hope to see you again in one of our webinars.
Thank you.
You can check the schedule of next webinars on the weblaw.ch/Brownback. There you find the schedule of the next webinars, which are mainly focused on topics of legal technology. Okay, thank you and goodbye.
Thank you. Thank you so much, Philip.
Thank you. Bye.
Bye.